You know, when you think about how our laws are made, you probably picture politicians debating in Parliament. But that's not the whole story. What if I told you some of our most important legal principles started with something as weird as a decomposed snail in a bottle? Yeah, seriously. Today, we're going to dig into the surprising ways Australian law is created and how we can all find ways to solve our own disputes.
So, let's just jump right in with this question. Can a decomposed snail really change the law? I know, it sounds completely bizarre, like a setup for a bad joke. But the answer is a definite yes. And this one strange story actually reveals something absolutely fundamental about how our entire legal system works.
All right, so to get to the bottom of this, we've got to go back in time. Not to a fancy courtroom or a big government building, but to a small cafe in Scotland way back in 1932. And the whole thing started with a single bottle of ginger beer that was hiding a pretty disgusting secret.
So this case, right, it's called Donahue versus Stevenson, and it is a wild ride. It's got everything. A really shocking discovery, a woman who absolutely refused to let it go, and a legal battle that basically invented a whole new area of law from scratch.
Okay, so the facts of what happened seem pretty straightforward. But, and this is a big but, there was a huge legal problem. See, Mrs. Donahue's friend was the one who actually bought the drink. That meant Mrs. Donahue didn't have a contract with the manufacturer. So legally speaking, who was responsible for what happened to her? The courts had no idea. They were in totally uncharted territory.
This is where it gets really, really important. Because what the court decided to do next wasn't just about Mrs. Donahue. It was about setting a rule for everyone, for the future. They created what's called a precedent, and it's a rule that has protected every single one of us as consumers ever since.
And this gets us to one of the two big sources of our law, common law. Honestly, the best way to think about it isn't like a rulebook. It's more like a storybook that's always being written. Every time a judge makes a decision in a new case, they're adding another page, another chapter that helps guide all the decisions that come after it.
So the judges had this puzzle. How do you hold the company responsible without a contract? Well, their solution was brilliant. They came up with this idea called the neighbor principle. And they said, basically, your neighbor in the eyes of the law is anyone you can reasonably expect to be affected by what you do. So for the ginger beer company, their neighbor wasn't just the shop that bought the drinks, it was the person at the very end of the line who is actually going to drink it.
And let's just trace the logic here, because it makes perfect sense. The court basically said, hey, that bottle was sealed. No one could check inside it after it left the factory, so the manufacturer was the only one who could control its safety. That simple fact creates a direct line of responsibility, a duty of care, straight from the company to the consumer.
And that is the absolute bombshell of this whole thing. This one single, frankly kind of gross case set this massive precedent. It literally became the foundation of modern negligence law, which is what holds companies responsible for making safe products. And it all started with one very unlucky snail.
Okay, so that's how judges can make law. But the law isn't made in a vacuum, right? What happens when the courts and our elected parliament interact? Well, to see that in action, we need to look at another monumental Australian case, the Mabo decision.
Just look at this timeline. It lays out a complete transformation of Australian law and history. For 200 years, the whole legal system was built on this idea of terra nullius, a Latin phrase that literally means land belonging to no one. But then in 1982, a man named Eddie Mabo kicked off a legal fight that was going to shake that foundation to its very core.
I mean, you can't overstate how huge this was. The High Court basically looked at 2 centuries of legal history and said, that was wrong. They threw out terra nullius, and by doing that, they created new common law. For the first time, Australia's highest court officially recognised that Indigenous Australians had their own laws and a continuous connection to the land that existed before 1788, and we now call that connection native title.
And this is the perfect example of the two big sources of our law kind of talking to each other. First, you have the judges in the High Court making a massive change to the common law with the Mabo decision. Then, right after, our elected parliament steps in and passes a formal law, a statute, called the Native Title Act. That statute basically took the court's big idea and created a clear rulebook for how would it all work in the real world. All right, so court cases about snails and land rights, they're epic, for sure. They change the whole country. But what about, real life? The kinds of problems most of us might actually run into. A fight with a neighbor, a problem with a builder. Do you really have to go through all the time, the stress, and the insane cost of a full-on court battle?
And the good news is, the answer is a huge, definite no. And honestly, for most of the disagreements that pop up in everyday life, knowing about the other options is one of the most powerful and useful things you can learn about the legal system.
It's all bundled under this term ADR, or Alternative Dispute Resolution. But really, you can just think of it as finding smarter, more practical ways to solve problems. It's often less about one person winning and the other losing, and more about finding a middle ground, a solution that actually works for everyone involved.
I mean, just take a look at this breakdown. It's night and day, right? Over on one side, you've got court. It's super formal, it can take forever, and it's incredibly expensive. Plus, a judge you've never met makes the final decision. But then look at mediation. It's cheaper, way faster, and the most important part, you are in control. You and the other person have to agree on the outcome. Arbitration is kind of in the middle, a bit more formal, but still way more flexible than court.
So, wow. From a gross snail in a bottle in Scotland, to a landmark land rights case that reshaped Australia, all the way to a simple negotiation table. What has this whole journey taught us about how our legal system really works?
At the end of the day, it's all about these three pillars holding up our system of justice. You've got the common law, which is constantly evolving with every new court case. You've got statute law, which our politicians create to address society's needs. And then you have ADR, which gives all of us practical tools to solve our own problems.
The big takeaway here is that the law isn't just some old dusty rulebook sitting on a shelf. It's a living, breathing thing. It's constantly changing, constantly adapting, shaped by huge court decisions, new legislation, and just the everyday need for regular people to find fair answers to their problems.
Which makes you wonder, doesn't it? As our society keeps changing, with new technologies, new ideas, new challenges, what's the next big shift going to be? What will be our generation's snail-in-a-bottle moment that ends up changing everything?